Bankruptcy annulment is a legal process that can end a bankruptcy before the normal discharge period expires, but strict legal requirements must be satisfied before an annulment will be granted. Under the Bankruptcy Act, there are generally three ways a bankruptcy can be annulled. The first is where the bankrupt pays all debts in full, including interest, trustee costs, expenses, and the trustee's remuneration. Once the trustee has satisfied all the liabilities connected to the bankruptcy have been paid, the bankruptcy is automatically annulled by operation of law. The second option is through a Section 73 proposal, sometimes referred to as a composition or scheme of arrangement. This allows the bankrupt to propose an agreement to creditors to settle the debts for less than the full amount owed. For a proposal to succeed, creditors must approve it by special resolution, requiring both a majority in number and at least 75% of the value of creditors voting in favour. If accepted, the bankruptcy is annulled immediately and the agreed arrangement becomes binding on the creditors. The third pathway is applying to the court for an annulment order. This generally occurs where the bankruptcy should never have happened in the first place. The court may annul the bankruptcy if satisfied that a sequestration order ought not to have been made, that a debtor's petition ought not to have been presented, or that the official receiver should not have accepted that debtor's petition. These applications often involve issues such as invalid debts, procedural defects, lack of proper service, abuse of process, or circumstances showing the debtor was not actually insolvent at the relevant time. Importantly, annulment is different from ordinary discharge from bankruptcy. An annulment effectively treats the bankruptcy as though it should not continue, and in many respects restores the person to the position they were before bankruptcy occurred. Property that vested in the trustee may revest in the individual, and the annulment can significantly affect the person's financial and commercial standing going forward. However, the bankruptcy annulment applications can be highly technical and often involve strict procedural requirements, complex evidence, and negotiations with creditors or trustees. Whether an annulment is realistically available depends heavily on the specific circumstances, including the reason for the bankruptcy, the financial position of the debtor, and the conduct of creditors and trustees throughout the process. Understanding whether bankruptcy can be annulled, what pathways are available, and what evidence is required can make a significant difference to the outcome and the ability to move forward financially and commercially. Contact us today for a free 30-minute consultation with our experienced team of insolvency professionals and let us help you protect your rights.